number 73, He v. Troon Management. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, Kenneth J. Gorman for the plaintiff appellant. I would like to reserve 2 minutes for rebuttal.
You may have 2 minutes, sir.
Thank you. Well, for the past 16 years, the First and Second Departments have uniformly held that under Administrative Code Section 7210, with the exception of certain exceptions not applicable to this case, landlords had a non-delegable duty to maintain the sidewalk abutting their property in a reasonably safe condition, and this included the removal of transient conditions. The First Department's decision ignored the terms of Section 7210, which expressly states that the failure to maintain a sidewalk in a reasonably safe condition shall include the negligent failure to remove snow and ice.
You're not saying that you don't still have to prove negligence.
I'm sorry?
You're not saying that you don't still have to prove negligence.
Absolutely. Yes, I mean, yes, you have to show negligence and proximate causation.
Constructive notice and all that, right?
They're all that.
Okay, so it's not strict liability.
It's not strict liability. But they have to, but they don't have to be, they could be a landlord out of possession or in possession. It doesn't matter, but it has to be the landlord that is that has the ultimate responsibility for maintaining the sidewalk.
Under that section, can the landlord ever delegate to the tenant under a provision of the lease?
I mean, the landlord can delegate to the tenant, but the landlord would still be liable to an injured third party.
He can't absolve himself by
That's
delegating to the tenant under that
I
section.
mean, that just becomes the third-party action, or, they bring him in as a co-defendant.
That's correct. Like, a tenant can be held liable to the owner for indemnification, but for the most part, tenants don't have any obligation or duty of care to pedestrians. I mean,
So you're saying you can delegate the work,
But not,
the actual work that needs to be done, but not the ultimate responsibility under the law?
I couldn't have said it better myself. I mean, there's policy issues behind this, and this court recognized that in Sangre, and when it discussed the legislative history in Vucetovic versus Epson, this court recognized that the legislative purpose underlying the enactment of Section 7210 was to incentivize abutting landlords to create safer sidewalks to pedestrians, because they're best situated to remedy sidewalk defects. Tenants, unlike owners, are often transient entities. They don't have the financial incentives that ties to the property, and often the financial ability to fulfill the statutory duty.
You know, there seems to be a line of cases from the First Department, Bing, Cepeda, Hay, and Fuentes, that seem to say that a landlord violation of, basically that the lease trumps the statute. You want to address some of those? Because that's been pretty consistently their ruling there. And
Yeah, but there are
maybe the
also some
conflict with the
cases, such as Chan versus Lee, from the First Department, in which some judge I know sat on the panel saying the opposite.
Sounds like a Feynman case.
So they're a little bit at war with themselves, aren't they?
It appears that way, but...
How does it compare to the Second Department?
Well, I mean, the First Department, up until even now, says that a landlord has a non-delegable duty to maintain the property in reasonably good repair. Now, it's non-delegable, but apparently the First Department appears to say this is non-delegable with regard to structural defects
I see.
and not with regard to transient conditions.
And what does the Second Department say about it?
The Second Department says that it's non-delegable with regard to all defects, whether it's transient or structural. If it was the legislature's intent to limit a landlord's non-delegable duty to repairing structural defects, the statute would have stated so. And it would not have included the removal of snow
Well, could
and
the
ice.
legislative history be understood to mean that all the legislature did was recognize there's a duty on a landlord, but instead of the city paying for the injuries, the landlord's going to pay for it. But under the existing framework at the time, an out-of-possession landlord was generally not responsible and didn't have that duty.
That's correct, which is why the city wanted to create a remedy for injured pedestrians. And this is what they did to rectify that situation, because under the previous statutory scheme, although landlords and tenants were responsible for clearing snow and ice and remedying structural defects.
No, but my question is, could the legislative history be interpreted to simply show that what was intended was to shift the responsibility for the payment to those who already carried the duty? And if an out-of-possession landlord didn't have that duty, they weren't going to carry the responsibility for the payment.
It's in the legislative history, and I think it's pretty clear. Also, the amicus brief for the Trial Lawyers Association set forth in Administrative Code Section 7211 and Section 7212 that landlords are responsible for getting insurance, not tenants in possession. And under 7212, the city can actually go after a property owner for unreimbursed medical costs that an injured party sustains, up to $50,000. So I think that the legislative history and the accompanying statutes that were enacted with 7210 clearly state that the ultimate responsibility lies with the landlord, although a tenant could be responsible for clearing snow and ice and remedying property defects. That's between the landlord and the tenant.
Thank you, counsel.
Thank you very much.
Counsel?
May it please the court, my name is Scott Taylor. I represent the respondents of the Troon Management defendants.
So can I just start where he sort of ended up, which is, why would the statute require a non-liable party to have insurance? I mean, why would they have that insurance requirement if there was no liability on behalf of the landlord?
Well, the administrative code shifted the responsibility for maintenance of sidewalks from the city.
I'm well aware. I spent many years.
Right, but I'm saying, and that's why they
in the city part. And that's a clear policy decision by the city council and Mayor Bloomberg to get the city out of the business of paying for all these trips and falls and whatnot on the sidewalk.
Right,
So we all understand that. But as part of that, they also required that landlords have insurance.
Well, I think those go hand in hand. I mean, they shifted
Right.
the responsibility and said, make sure you have the insurance to
But if they
cover it.
wanted to protect themselves and they were thinking, they were recognizing, they were anticipating that tenants might have a responsibility under the lease to clear ice and snow, why wouldn't it have said that the tenant or the owner or whoever is responsible for snow removal has to have insurance? Why wouldn't it do that?
I mean, I don't know why they did or didn't do what they did. I just know that.
Well, and how would they enforce that if they did?
How would
they enforce it against tenants
couldn't.
who are transient? So doesn't that support the interpretation that it was meant, that the obligation was meant to be non-delegable on the part of, the obligation to compensate people for their injuries was meant to be non-delegable on the part of
I mean,
the
I think
owner.
if they intended 7210 to be non-delegable, they could have said in the provision that it's non-delegable. That's an entirely different provision, and this provision is silent as to that. And as we've already, and the appellant
But don't we
acknowledged.
have to, since it says neither it is or it isn't non-delegable or delegable?
Correct.
Don't we have to look at it in the context of the entire statutory scheme here?
Well, I think you have to
And the
look.
purpose.
I think you have to look at the totality of everything, including that. I do, yes. But by looking at it the way appellant wants this court to look at it, you're basically eliminating the concept of the out-of-possession landlord. And because you're basically saying there is no such thing. You can buy a building And you can move to Florida and you can require the tenant to remove snow and ice, but if it snows, you better have somebody up there. And that's going to have a ripple effect because the
But
cost of
why
that.
can't the landlord, why can't the owner have a separate agreement with the tenant that if I end up having to pay for this, you have to indemnify me?
Well, they can, and they do, but that doesn't, the separate agreement to indemnify, I mean, there's an indemnification provision within this lease. So, I mean, they can do that.
Would we have
but-
to overrule Sangare, which we ruled on in 2016, if we were to go your way?
I do not believe you do, Your Honor.
Tell me why.
And I'll tell you, and it also addresses one of the questions you placed to the appellant, which is, Sangare is not a transient condition, which is what we have here. You had asked about the second department.
So it's the structural.
Exactly, and that's consistent with Guzman and everything else this court has done. And when you asked before if there are second department cases that go against Bing and Cepeda and Fuentes, and the short answer to you is no, there are not, because all the cases that are cited, because that's all the cases that there are structural defect cases.
But does 7210 make any distinction? You're talking about what's in and what's not in the language. Does it make any distinction between structural defects and transient conditions?
Well, I mean, there's separate provisions for each. I mean, you know, they talk about specifically snow separately from the structural defects.
But they lump them together and under the same provision.
It's in the same provision, yes, Your Honor. I mean, but they say.
So they don't say that certain things apply to some things and not others. They include them all. They include all of them. Under
just-
7210.
Yeah.
That includes the structural and the non-structural.
Yes, it does, Judge.
So what basis would there be then for us to interpret that?
Well, I mean, I think
Differently.
what really is before this court is one of policy. I mean, it's a question, you know, the only reason we are here is because Mr. He was not satisfied with the exclusive remedy provided in Workers' Compensation Section 11. Had Mr. He been a pedestrian or a delivery
That
man.
pretty much covers about 70% of the tort cases we see, though.
Well,
So
but
that's-
not most of the sidewalk cases. I
No,
mean, you
but
know,
it covers it, a lot of workman's comps, fall downs, labor law cases, I mean, it covers a lot of those kind of cases.
it certainly does, but not, I mean, predominantly, most sidewalk cases are trip and falls, slip and falls.
Certainly all
and
the
they're-
ones under this statute are, so.
Yes, and had he been a delivery man or
Let me ask you this.
pedestrian, he could have sued
Let
the
me ask you a
tenant.
question.
Yes.
You were listening to the other arguments. Can the owner here escape liability by executing the lease
Yes,
fully?
for this, I mean, not for, again, a structural
The owner be
defect.
liable, and then he'd have to go after the tenant?
I'm sorry, Judge, I just didn't hear
Wouldn't the
you.
owner be liable, and then he would have to go after the tenant through either?
No, I
indemnification?
believe that the owner shifted the liability pursuant to the terms of the lease. He says, I'm going to be out of possession, you maintain the sidewalk, and he did. Now, that wouldn't alleviate his responsibility for a structural defect under Sangare and that line of cases. But for transient conditions, that's imposing a duty on him to retain a contractor or an employee, a cost which I assume will ultimately be shifted onto the tenants.
One of the things that strikes me is, on the displacement argument, that's a common law argument, but here we have a statute that makes it a little bit different in the creation of the duty. Do you agree with that?
I agree that the statute does do that, but, you know, when you read the
That
language,
extra layer work against your side of the argument?
I do not believe so, Your Honor. I mean, I believe when you read this provision and the Bing case and the Cepeda case and all those, it makes it clear that, you know, there is such a thing as an out-of-possession landlord. And he can protect himself by shifting that responsibility.
under the-
I mean,
under
how
the-
can he be negligent for something that, a snow event, when he's not there?
Under the out-of-possession landlord doctrine, doesn't that require the landlord to transfer control of the property on which the person was injured?
Yes,
So we're talking about a sidewalk here, no?
yes.
So talk me through that.
Well, but he doesn't own, I mean, the landlord doesn't own the
So
sidewalk.
how
The
does
city
he
still owns it.
Right, so we're talking, you keep mentioning the out-of-possession landlord doctrine. I want to know how that squares with the fact that this is a sidewalk that's owned by the city, and why this isn't not a straight statutory interpretation case.
Well, I mean, I think it's just very simply, a landlord purchases a building, he doesn't purchase the sidewalk. He has a duty to maintain that sidewalk under the administrative code.
So would you agree that we decide this case under the statute, and that's our limited analysis? Is that what you are arguing?
Yeah, I think it's the administrative code, 7-210.
Okay, just want to make sure.
Yeah.
Thank you, Counsel.
Thank you, Your Honors.
Counsel, rebuttal?
My colleague stated that the statute doesn't specifically state non-delegable duty, but no statute really does that imposes a non-delegable duty. For instance, Labor Law Section 241 states that all contractors and owners shall furnish proper protection. And multiple dwelling law, Section 78, states that the owner shall be responsible for compliance with the provisions of this section to keep the dwelling in good repair. The word shall means non-delegable, and that's what courts have interpreted for decades. With regard to the workers' comp issue, there's really no distinction between a landlord's non-delegable duty under Section 7210 and a landlord's non-delegable duty under the labor law. Just as the Third Department stated in Nephew versus Barcombe, which we cited pages 13 to 14 of our brief, that Labor Law Section 241 makes no distinction between...
We don't need to go to the labor law, though, to resolve this case.
No, but I'm just making an analogy.
Let's just be clear, because
We don't.
that's dangerous territory.
I understand that, but the labor law, it doesn't make a distinction between an in-possession landlord and an out-of-possession landlord. 7210 doesn't make a distinction between an in-possession landlord.
I get the point.
So-
I'm just saying I don't need to rely on labor law
Understood.
cases to
Understood.
interpret the statute.
If there's any further questions,
Thank you,
I'll just
counsel.
rest on my briefs. Thank you very much, Judge.